You may have heard of Bitcoin. You know, that's the sort of possibly best known of these so-called cryptocurrencies. And don't worry, I'm not going to try and sell you any. But there's always been this big mystery as to who invented it, and allegedly it was this Japanese guy. However, this Australian guy said, actually, that's my pseudonym and I invented it. And there was lots of controversy in the crypto community about whether this was true or not. And somebody, you know, a lot of people called him out on this, but somebody called him out in sort of quite, shall we just say, strenuous terms. Uh, so the guy brought a claim for defamation and said, "You are defaming me for saying I am not the inventor of Bitcoin, and it's cost me billions of billions. You know, I've lost out on all sorts of stuff." So he sued for defamation, and that's what we're going to talk about: defamation. You know, not crypto. Um, and the interesting thing about it is he actually succeeded in his defamation claim. The judge said, "Yep, this was defamatory. Him claiming you weren't, you know, who you say you were." Although it's still a bit nebulous as to whether it's actually accepted that, okay, is this the guy, or was it just the allegations of, you know, other deceit? But anyway, so he wins his case. However, the judge said, "You have perjured yourself on a large scale, and you've produced all this false evidence to show this loss. So what am I going to do about it? Okay, I'm going to take that into account. I'm going to award you £1 in damages. £1 in damages." Now, what's interesting about that is that they actually reduced the damages because of conduct. Now, usually, you know, I've discussed before how conduct can be reflected in costs. You know, it's like, you know, you will not get your costs that you should have done because of this, or if you're paying the costs, you'll pay them on an indemnity basis. But what he said in this particular case was, well, no, because your conduct was so egregious, I'm actually going to reflect that in damages, and you're getting a quid, and that's it. So that's very interesting. Now, this is something that we see a lot in road traffic cases. There's actually a statutory provision that says if somebody is manifestly dishonest in a road traffic claim, because it's so prevalent, that you can actually reflect that in the damages and say, yeah, you should have got all this money, but now I'm not going to give you it, as well as the cost aspect. But back to the defamation case. I mean, the judge was very clear. He said, look, the mere fact that sometimes people fail in parts of their claims, so they succeed, and the judge will say, well, I don't accept that loss was proven, all this. He said, you know, that's just run-of-the-mill stuff. You wouldn't be penalised in damages for that. You'd get the appropriate damages for the harm caused, and we might reflect it in costs and say, well, we spent a lot of time arguing about this bit. Remember, you know, it's that Cadwell thing. You know, we spent a lot of time arguing about this bit, and you didn't succeed, so you're not getting any costs for that, or something like that. But yeah, it's just interesting that they actually did it as a punishment this time. So I'm just really worried now that all the road traffic lawyers will suddenly be muscling in on defamation. But anyway, yeah, like I say, if you found that interesting or useful, or, you know, just fill some time or whatever, please consider clicking the like button and also possibly subscribing.